Good day, everyone. Today we will be discussing the provisions to pledge or common to pledge in mortgage. Starting off with Article 2085. 2085 provides that the following requisites are essential to the contracts of pledge and mortgage. Okay, pledge and mortgage. Let's start with the first paragraph, that they be constituted to secure the fulfillment of a principal obligation. Ako yung gi-emphasize earlier na there are only two principal contracts, 'di ba? Si loan ra ug si deposit. All other contracts are accessory contracts. And this is one of the examples of an accessory contract, kaning contract of pledge. Nga giingon gyud diri sa first paragraph nga this is constituted to secure the fulfillment of a principal obligation, meaning this cannot exist without the existence of a principal obligation. Number two, that the pledger or mortgagor be the absolute owner of the thing pledged or mortgage. Question, kanus aman sila kailangan absolute owner of the thing pledged or mortgage? The answer is, according to Viuda Di Bautista versus Marcus, the pledgor or mortgagor must be the actual owner at the time of the constitution of the pledge or mortgage. It has to be at the time of the constitution of the pledge or mortgage, not before, not after, but it has to be at the time of the constitution of the pledge or mortgage. Okay? Number three, that the persons constituting the pledge or mortgage have the free disposal of their property, and in the absence thereof, that they be legally authorized for the purpose. Remember nga, the act of pledging or mortgaging is an act of strict ownership, involving as it does the alienation or transmission of real right in property. So it could be that the pledgor or the mortgager in this case suffers from civil interdiction or garnishment or attachment or receivership. So you need to take note of the requisites that are essential to the contract of pledge and or mortgage. Next is that third persons who are not parties to the principal obligation may secure the latter by pledging or mortgaging their own property. Right? Now, 2086 provides that the provisions of Article 2052 are applicable to a pledge or mortgage. Unsa day naa sa 2052, ningon ang 2052, a guarantee cannot exist without a valid obligation. Di gi-amplify ra ang atong giingon nga ang pledge is an accessory undertaking, an accessory contract. Okay? Nevertheless, ningon ng 2052, a guarantee may be constituted to guarantee the performance of a voidable or an unenforceable contract, and it may also guarantee a natural obligation. Okay? Now on to 2088. 2088 provides that the creditor cannot appropriate the things given by way of pledge or mortgage or dispose of them. Any stipulation to the contrary is null and void. Now look at the example in this slide. In this example, si Kyle borrowed money from JC and gave a piece of land as security by way of mortgage. It was expressly agreed by the parties in the mortgage contract that upon non-payment of the debt by Kyle, the mortgaged land would belong to JC. Now, question is, if Kyle defaulted in paying, would JC now become the owner of the land? The answer is no, because this would be in the nature of pactum commissorium as provided for in 2088. Okay? But if, say, Kyle borrowed money from JC under the agreement that if, at the expiration of the period stipulated, the sum loaned should not be paid, it would be understood that the land owned by Kyle be considered absolutely sold to JC for the said sum, and then no amount was made by Kyle in a time fixed. In view of the refusal of Kyle to deliver the property, JC brought action to recover the property and rents from Kyle. Is the contract in question of a pactum commissorium? Is the contract in question of the nature of a pactum commissorium? The Supreme Court in the case of Alcantara versus Alinea said that we have in this case a contract of loan and a promise of sale of a house and lot, the price of which should be the amount loaned, if within a fixed period of time should amount or such amount should not be paid by the debtor or vendor of the property to the creditor vendee of the same. The fact, according to the Supreme Court, the fact that the parties have agreed at the same time in such a manner that the fulfillment of the promise of sale would depend upon the non-payment or return of the amount loaned has not produced any charge in the nature and legal conditions of either contract or any essential defect which would tend to nullify the same. The property, the sale of which was agreed to by the debtors, does not appear mortgage in favor of the creditor because, in order to constitute a valid mortgage, it is indispensable that the instrument be registered in the Registry of Property in accordance with the Civil Code. Okay? So, niingon ng Supreme Court, for this reason, for the reason of the said document is not vested with the character and conditions of a public instrument. So, by the aforesaid document, said property could not have been pledged, it could not have been not being a personal property, and notwithstanding the double contract, the debtor continued in possession thereof, and the said property has never been occupied by the creditor. Further, niingon ng Supreme Court, neither was there a contract of antichresis by reason of the said contract of loan as it provided in the Civil Code, inasmuch as the creditor plaintiff has never been in possession thereof, nor has he enjoyed the said property, nor for one moment ever received its rents. So, in this case, the Supreme Court said it is a principle of law invariably applied by the courts in the decisions of actions instituted in a manner of compliance with obligation that the will of the contracting parties in the law of contracts and that of a man obligates himself to that of which he promises to be bound. Okay? So in this case, ngayon ng Supreme Court, this would not be considered and a nature of a pactum commissorium. So now on to Article 2089. Article 2089 niingon, a pledge or mortgage is indivisible even though the debt may be divided among the successors in interest of the debtor or of the creditor. Therefore, the debtor's heir who has paid a part of the debt cannot ask for the proportionate extinguishment of the pledge or mortgage as long as the debt is not completely satisfied. Neither can the creditor's heir who received his share of the debt return the pledge or cancel the mortgage to the prejudice of the other heirs who have not been paid. From these provisions is expected the case in which there being several things given in mortgage or pledge, each one of them guarantees only a determinate portion of the credit. The debtor in this case shall have a right to the extinguishment of the pledge or mortgage as the portion of the debt for which each thing is specially answerable is satisfied. So, example, Kyle borrowed from JC 20,000 pesos, and to guarantee the payment, Kyle pledged his diamond ring worth 15,000 pesos and a pair of earrings worth 5,000 pesos. Now, if Kyle pays 15,000 pesos, can he ask for the return of both the ring and the earrings given to secure the entire obligation of 20,000 pesos? The answer is no, because according to Article 2089, pledge is indivisible. Okay? But suppose A borrowed from JC 20,000 pesos. And to guarantee payment, A pledged his diamond ring worth 15,000 pesos and a pair of earrings worth 5,000 pesos. A dies, leaving B and C as his heirs. B pays 15,000 pesos to JC. Can B now ask for the return of the ring? The answer is no, because the second paragraph of 2089 would say the debtor's heir who has paid a part of the debt cannot ask for the proportionate extinguishment of the pledge or mortgage as long as the debt is not completely satisfied. Now, another example, creditors are L and M, and B borrowed 20,000 pesos, and to guarantee payment, P pledged his diamond ring worth 15,000 pesos and a pair of earrings worth 5,000 pesos. If P pays L 15,000 pesos, L cannot return the ring to the prejudice of M, who has not received his share. The same is true if L is the only creditor and he also dies, leaving Y and Z as his heirs, and P pays Y 15,000 pesos. Okay? But note that if there are several things given in pledge or mortgage and each one of them guarantees only a determinate portion of the credit, the rule of indivisibility will not apply. So now let's proceed to chapter 2 on pledge, article 2093. Okay? 2093 provides that in addition to the requisites prescribed in Article 2085, it is necessary in order to constitute the contract of pledge that the thing pledged be placed in the possession of the creditor or the third person by common agreement. Nakabaw naman ta na when we talk about pledge, mura na siya ka ng, sa atong layman's term, it's like prinda. Okay? Prinda. Now, question is it important that there be a physical delivery of the thing pledge? Ordinarily, ningon ng Supreme Court, there has to be an actual delivery. Okay? There has to be an actual delivery. But in exceptional circumstances, like in the case of Banco Español versus Peterson, the Supreme Court would say na if it would be an unreasonable requirement for those goods or things to be delivered, constructive delivery will suffice. Okay? Kay kung ang gipledge here would be voluminous goods stored in a warehouse, and what was delivered was just the key to the warehouse, is it enough? Ngayon, the Supreme Court, yes, because it would be an unreasonable requirement for those goods or things to be actually delivered. Hence, constructive delivery will suffice in this case. Also, in the case of Yongsho versus PNB, they entered into an agreement in a public instrument that while the ships will be manned by the crew of Yongsho, they will be under the control and supervision of the board of directors of the PNB. So the Supreme Court said here that there was a constructive delivery. Now, my question is, why is it so important to have delivery? Because as mentioned earlier, delivery will result in the perfection of the contract. Kaya kung perfected na ang contract, the pledgee or the mortgagee can now exercise his rights in relation to the said contract. Okay? Now, 2102, some of the provisions are matters of reading. So I'll just skip those articles and just proceed with 2102. 2102 provides that if the pledge earns or produces fruits, income, dividends, or interest, the creditor shall compensate what he receives with those which are owing him. But if none are owing him, or insofar as the amount may exceed that which is due, he shall apply it to the principal. Unless there's a stipulation to the contrary, the pledge shall extend to the interest and earnings of the right pledged. In case of pledge of animals, their offspring shall pertain to the pledger or owner of the animal's pledge, but shall be subject to the pledge if there is no stipulation to the contrary. All right, an example would be this: a carabao is delivered to a pledgee who owns the baby of the carabao. Of course, the pledger because he is the owner of the carabao. Question, can he demand that the pledgee deliver to him the offspring? No, because niingon diri ang balaod nga it shall be subject to the pledge, except if there is a stipulation to the contrary. Okay? Now, 2112, 2113, 1415. Okay, kanilang siya. 2115. The sale of the thing pledged shall extinguish the principal obligation, whether or not the proceeds of the sale are equal to the amount of the principal obligation, interest, and expenses in proper cases. If the price of the sale is more than the said amount, the debtor shall not be entitled to the excess unless it is otherwise agreed. But if the price of the sale is less, neither shall the creditor be entitled to recover the deficiency, notwithstanding any stipulation to the contrary. Ganahan kay ko pagka-istorya ani diri sa balaod. Di man ilang nga kung whatever proceeds ang mahalin, if mahalin siya in a public auction, ang ting pledge in case of default on the part of the principal debtor, whatever proceeds, mo na to siya mo cover sa principal obligation as well as the interest and the expenses. Okay? And if there be a deficiency, dili jud ka maka-claim og di jud ka maka-recover og deficiency bisan pag naay stipulation to the contrary. Pero if there be an excess sa proceeds, ang rule sad is di ka maka-recover except kung naay provision or stipulation to the contrary ang inyong sabot. Okay? Now on to Act 3135. This pertains to an act to regulate the sale of property under special powers inserted in or annexed to real estate mortgages. This act basically regulates the extrajudicial foreclosures which comes into play upon default of the obligor of the real estate mortgage. Okay? Now, let's proceed to the general principles. Extrajudicial foreclosure should be expressly allowed in the document reflecting the deed of mortgage. Remember that when you are the creditor slash the mortgagee, creditor mortgagee, you have to ensure that the document or the deed of real estate mortgage must contain an express provision allowing extrajudicial foreclosure. Okay? Otherwise, di ka pwedeng maka-extrajudicially foreclose. You have to go to court and go through judicial foreclosure. Okay? Remember, there must be a special power to extrajudicially foreclose the mortgage and attached or made an integral part of the real estate mortgage contract. Now, Section 1. When a sale is made under a special power inserted in or attached to any real estate mortgage, hereinafter made as security for the payment of the money or the fulfillment of any other obligation, the provisions of the following shall govern as to the manner in which the sale and redemption shall be effected, whether or not the provision for the same is made in the power. Okay? Remember that there's the subject matter for this is a real property or an immovable. And also remember that a property can be foreclosed in case of default on the part of the obligor. The real estate mortgage effectively creates real rights and it follows the property such that in subsequent transfer, the transferee must respect the mortgage subject to the requirement that the same is annotated in the title or that the transferee had knowledge of the existence of the real estate mortgage. Okay? It has to be respected and you have to take note of these basic principles. Also remember that ownership is not transferred to the mortgagee. The property will stand only as a collateral for the satisfaction of the claim in the event there is default on the part of the obligor. And also remember that the invalidity of the accessory will not render invalid or void the principal obligation upon which it is made to rest. Mao gyud na ang mga basic principles that you need to really commit to memory and master by heart kaning mga basic principles in contracts, no? Nga kung accessory, kung ma-void man gani na, it will really not affect the principal obligation. Okay? Now on to the procedure. I think procedure will be tackled in your procedure, but just an idea on how it works in Act 3135. Applications for extrajudicial foreclosure of mortgage shall be filed with the executive judge through the clerk of court who is also the ex officio sheriff. Now, next is ang notice shall be given by posting notices of the sale for not less than 20 days in at least 3 public places of the municipality or city where the property is situated. And if such property is worth more than 400 pesos, such notice shall also be published once a week for at least 3 consecutive weeks in a newspaper of general circulation in the municipality or city. This act is just very short. You can just read it, no, in your free time. Now, where's the venue man? Ang venue is the province where the property is situated. And when parties stipulate the city or municipality within the province where property is situated, pwede sad na. And the sale cannot be made legally outside of the province in which the property sold is situated. And remember nga, if there are no restrictive words or exclusivity of venue of the sale, the stipulated place should be construed as an additional but not a limiting venue. Now, Section 6. In all cases in which an extrajudicial sale is made under the special power herein before referred to, the debtor, his successors in interest, or any judicial creditor or judgment creditor of the sale or of the said debtor, or any person having a lien on the property subsequent to the mortgage or deed of trust under which the property is sold, may redeem the same at any time within the term of 1 year from and after the date of the sale. 1 year, remember ha? The period of redemption is 1 year. Pero note the rule if the creditor is a bank. Because your redemption period, kung ang creditor kay banko is only 3 months, anytime after the registration of the sale. Mas mubo siya. Okay? So, how do we count the 1 year period man of redemption? How is it counted? The Supreme Court in the case of Reyes versus Noble has encountered this issue, okay? Whether or not the period of redemption of property sold at public auction pursuant to an extrajudicial foreclosure of real estate mortgage under Act 3135 as amended is to be counted from the date of the execution of the certificate of sale by the sheriff or from the date of the registration of the corresponding certificate of sale issued by the sheriff in the office of the Register of Deeds concerned. In this case, ang theory sa parties kay kane, the Land Registration Commissioner is of the opinion that the above quoted provision is not the only pertinent and controlling law on the matter, especially when it is taken into consideration that the land involved is registered land under the torrents system. The commissioner maintains, and so held in the resolution appealed from, that Section 6 kono of Act 3135 should be applied to the present case together with Sections 30 to 35 of Rule 39 of the Rules of Court with respect to redemption, Rule 27 or Section 27, Rule 39 of the said rules, and Section 71 of Act 496 with regard to the filing of the sheriff's certificate of sale, as well as Act 496 with regard to the registration of the certificate of sale. Now, ang theory sa petitioner is that in sales of property at public auction pursuant to an extrajudicial foreclosure of real estate mortgage under 3135, the period of redemption should be reckoned from the date of the auction sale, which he contends is the express mandate of the law. Now, yun sa mga pag-rule sa Supreme Court. The Supreme Court ruled that the property involved in the present case is a registered land. It is the law in this jurisdiction that when property brought under the Operation of Land Registration Act is sold, the operative act is the registration of the deed of conveyance. The deed of sale does not take effect as a conveyance or bind the land until it is registered. Okay? Undoubtedly, ningon sa Supreme Court to be in consonance with this well-settled rule, Section 24, Rule 39 of the Rules of Court provides that the duplicate of the certificate of sale given by the sheriff This is before rule the new rules or the civil procedure was amended. So let's assume that this was under the old rules. Na ningon ng Supreme Court undoubtedly to be in consonance with this well-settled rule in Section 24, Rule 39, provides that the duplicate of the certificate of sale given by the sheriff who made the auction sale to the purchaser must be filed, meaning it has to be registered in the office of the Register of Deeds of the province where the property is situated. The Supreme Court concluded, therefore, that the date of the sale mentioned in Section 6 of Act 3135 as amended should be construed to mean the date of registration of the certificate of sale in the office of the Register of Deeds concerned. Only after the lapse of 12-month redemption period from the date of registration of the certificate of sale and in the absence of any redemptioner within the said period may the deed of final sale be executed in favor of the purchaser, who may then consolidate the title of the property in his favor. Now, is it necessary to have two bidders for a proper conduct of a sale? Kailangan ba nga there are two bidders for a proper conduct of a sale? In the case of Spouses Certeza versus PSB decided in March 5, 2010, the issue was whether the auction sale conducted by virtue of the extrajudicial foreclosure of the mortgage should be declared null and void for failure to comply with the two bidder rule. Supreme Court in the case of Spouses Certeza versus PSB held that the requirement for at least two participating bidders provided in the original version of AM number 9910050 is not found in Act 3135. Hence, in the resolution of the Supreme Court and Bank dated January 30, 2001, we made the following pronouncements. It is contended that this requirement is not found in Act 3135 and that it is impractical and burdensome considering that not all auction sales are commercially attractive to prospective bidders. Ningon pag ang Supreme Court, the observation is well taken. Neither Act 3135 nor the previous circulars issued by the court governing extrajudicial foreclosures provide for a similar requirement. The two-bidder rule is provided under PD number 1594 and its implementing rules with respect to contracts for government infrastructure projects because of the public interest involved. Although there's a public interest in the regularity of extrajudicial foreclosure of mortgages, the private interest is predominant. The reason, therefore, for the requirement that there must be at least two bidders is not as exigent as in the case of contracts for government infrastructure projects. So just take note of that. The Supreme Court further said that the new requirement will necessitate republication of the notice of auction sale in case only one bidder appears at the scheduled auction sale. This is not only costly, but more importantly, it would render not the binding effect of the publication of the originally scheduled sale. Hence, the CA, according to the Supreme Court, correctly ruled that it is no longer required to have at least two bidders in an extrajudicial foreclosure of mortgage. Now, another issue is whether personal notice to the debtor mortgager of the extrajudicial foreclosure is not necessary despite the parties' stipulation in their real estate mortgage contract requiring personal notice thereof. Niingon ng Supreme Court in this case, note the jurisdictional requirements under Section 3, which means that personal notice is not necessary. Nevertheless, parties to the REM are not precluded from exacting or imposing additional requirements. The general rule is that personal notice to the mortgagor in extrajudicial foreclosure proceedings is not necessary and posting and publication will suffice. Section 3 of Act 3135 governing extrajudicial foreclosure of real estate mortgages as amended by Act 4118, requires only posting of the notice of sale in 3 public places and the publication of that notice in a newspaper of general circulation. The exception is when the parties stipulate that personal notice is additionally required to be given the mortgagor. Failure to abide by the general rule or its exception renders the foreclosure proceedings null and void. Globals, in this case, according to the Supreme Court, Global's right to be furnished with personal notice of the extrajudicial foreclosure proceedings has been established. Thus, to continue with the extrajudicial sale without proper notice would render the proceedings null and void. Now, on to the posting requirement. I think these are matters of procedure, so we will just skip this. But just try to read it if you have the time. Also, the issuance of the certificate of posting. These are just matters of procedure, no, that may be expounded in your subjects in rules of procedure, like in civil procedure and special proceedings. Kani, applicability of Act 3135 to pledges. Ning ingon ang Supreme Court in Yonshua versus PNB, no, na this law refers only and is limited only to foreclosure of real estate mortgages. So whatever formalities there are in Act 3135 do not necessarily apply or do not really apply to pledges. That just take note of that. Now on to Antichresis. Unsa may concept aning Antichresis? Antichresis is a contract wherein the creditor acquires the right to receive the fruits of an immovable of his debtor with the obligation to apply them to the payment of the interest if owing and thereafter to the principal of his credit. Remember nga the amount of the principal and of the interest shall be specified in writing. Otherwise, the contract of antichresis shall be void. Okay? Otherwise, the contract of antichresis shall be void. Mo ni ang instance kaning uso sa mga bukid or sa mga probinsya wherein may ka mangutang ko nimo akong itagana ako ang kamanggahan. So, si creditor in this case will have the right to receive the fruits of that kamanggahan. Ang una niyang buhaton is ang proceeds sa fruits will be applied to the interest kung naay mo nga interest and then thereafter to the principal obligation until ma-fully paid. And this undertaking must be reduced in writing. Otherwise, void ang contract of antichresis. Now on to chattel mortgage, no? Chattel mortgage, personal property is recorded in a chattel mortgage register as a security for the performance of an obligation. If the movable, instead of being recorded, is delivered to the creditor or a third person, the contract is a pledge and not a chattel mortgage. Tanawan ninyo ang distinction, okay? The provisions of this code on pledge, insofar as they are not in conflict with the chattel mortgage law, shall be applicable to chattel mortgages. Example, A obtained a loan. He used the money and bought a car. Okay? A obtained a loan. He used the money and bought a car. As security for the payment of the loan, he subsequently mortgaged the car with the bank. When A failed to pay 2 successive installments, the bank foreclosed the chattel mortgage of the car. There was a deficiency. May the bank still recover the deficiency or will recto law apply? Sunday ng recto law. Recto law is actually embodied in Article 1484 of the new Civil Code, which provides for the remedies of a seller in the contracts of sale of personal property by installments. Note that Article 1484 of the new Civil Code incorporates the provisions of Act 4122 passed by the Philippine legislature in 1939, known as the Installment Sales Law or the Recto Law, which then amended Article 1458 of the Civil Code of the Philippines. Okay? Remember lang na nga kani siyang 1484 provides for the remedies of a seller in contracts of sale of personal property by installments. Okay? The Recto Law comprises articles from 1484 to 1486 of the Civil Code. It was added to the Civil Code to prevent abuses in the foreclosure of chattel mortgages, such as when the mortgagee creditors foreclosed mortgage property, bought them at a low price on purpose, and then prosecuted the mortgagor debtors to recover the deficiency. So, unsa may naa sa Article 1484 of the new Civil Code. Under Article 1484 of the new Civil Code, in a contract of sale of personal property, the price of which is payable in installments, the vendor may exercise any of the following remedies. Any of the following remedies. Una, exact fulfillment of the obligations should the buyer fail to pay any installment. Ikaduha, cancel the sale should the buyer's failure to pay cover two or more installments. Okay? Ang timan A na ay notice of rescission that is being sent, and then there is a taking of the possession of the subject matter, and then there's a filing of an action for rescission. Ikatulong a remedy is foreclosure of the chattel mortgage on the thing sold if one has been constituted should the buyer's failure to pay cover two or more installments. Note here that the mortgagee creditor is barred from the recovery of deficiency. Okay? And you have to remember ni ingon gyud o nga any of the following remedies. It means that this remedy is alternative. Okay? Remedies have been recognized as alternative, not cumulative, in that the exercise of one would also bar the exercise of the other. They cannot also be pursued simultaneously. If the seller should foreclose on the mortgage constituted on the thing sold, he shall have no further action against the purchaser to recover any unpaid balance of the price. Any agreement to the contrary shall be void. So in the problem earlier, may the bank still recover the deficiency or will recto law apply? Unsa to yung question ganiha? The question is, A obtained a loan, he used the money and bought a car as security for the payment of the loan. He subsequently mortgaged the car with the bank. And then when A failed to pay two successive installments, the bank foreclosed the chattel mortgage. There was a deficiency. May the bank still recover the deficiency or will recto law apply? And so my answer, may the bank still recover or recto law apply? The answer is yes, the bank can still recover because recto law is not applicable in this case. Timan nga ang recto law will only apply to sale on installments. In this case, iyahan na gyud to, na iyahang gi-mortgage lang subsequently ang iyahang car. Okay? Now, kani, another example. Kyle constituted a chattel mortgage over the building he erected on his land as well as the newly bought machinery stored therein when he borrowed 1 million to secure his obligation from JC. Thereafter, a judgment was rendered against Kyle in favor of Mavin, who had the building and machinery levied upon to satisfy the judgment. Question, is the chattel mortgage binding on Mavin? It would appear that ang binding rani would be the newly bought machinery stored in the building, diba? Because valid siya nga chattel mortgage. Pero with respect to the building, since this is chattel mortgage, kung may kag building, it has to be in a form of real estate mortgage. It would not bind Mavin. Meaning, kung mo default si Kyle, so kung mo-default si Kyle, can he validly invoke that the chattel mortgage is void because the subject matter is unimmovable? No, because stopped na siya from claiming it. Okay? But is it binding to third persons? No, because it would only be up to the extent of the newly bought machinery stored therein. Okay? Now, concurrence and preference of credits. This would cover 2036 to 2251. When concurrence of credits, this implies the possession by two or more creditors of equal rights or privileges over the same property or all the property of the debtor. Timan ilang ha, na ay two or more creditors of equal rights and privileges. over the same property or all the property of a debtor. Maunang na ay concurrence of credits. Kaya na may two or more creditors. Okay? Preference is the right held by a creditor to be preferred in the payment of his claim above others out of the debtor's asset. Okay? Now, unsa may nature and effect of preference? A preference is an exception to the general rule. For this reason, the law as to preference is strictly construed. Preference does not create an interest in property. It creates simply a right of one creditor to be paid first the proceeds of the sale of property as against another creditor. The law does not give the creditor who has a preference a right to take the property or sell it against another creditor. It is not a question of who takes or sells, it is one of the application of the proceeds after the sale of payment of the debt. You also have to remember that the right of preference is one which can be made only by being asserted and maintained. If the right claim is not asserted or maintained, it is lost. Where a creditor released his levy, leaving the property in possession of the debtor, thereby indicating that he did not intend to press his claim further as to that specific property after that act, his claim to preference, if one had been asserted by him, could not exist because he had ceased to contest. He did not maintain. He, in effect, abandoned any claim of preference. Now, when is the rule of preference applicable? This applies when there are two or more creditors having separate and distinct claims against the same debtor who has an insufficient property. This is also applicable when the debtor is insolvent, having more liabilities than his assets. And it is a matter of necessity and logic that the question of preference should arise only when the debtor asserts or when the debtor's assets are insufficient to pay his debts in full. Okay? So let's now start with the general provisions. Article 2036, the debtor is liable with all his property, present and future, for the fulfillment of his obligations subject to the exemptions provided by law. As a rule, remember nga ang debtor is liable with all his property, present and future, for the fulfillment of his obligation. But there are, of course, exempt properties, which you already know in the past, di ba? Present property niya kaning provided for by the family code, provided for by the rules of court. What are these properties? Kanang family home. Family home that is constituted by the husband and the wife, and those that is constituted by the family or as a family residence. Okay? Now, of course, there are exceptions which are basically matters of reading. So I encourage everyone to just read those articles. It also covers future property, those related to the insolvency of the debtor, also property in custodia lihes and of public auction. Article 2237 provides that insolvency shall be governed by special laws insofar as they are not inconsistent with this code. 2038, so long as the conjugal partnership or absolute community subsists, its property shall not be among the assets to be taken possession of by the assignee of the payment of the insolvent debtor's obligations, except, of course, insofar as it has redounded to the benefit of the family. If it is the husband who is insolvent, the administration of the conjugal partnership of absolute community may, by order of the court, be transferred to the wife or to a third person other than the assignee. So, what's my rule when it comes to undivided share interest of a co-owner? 2239 provides that if there is a property other than that mentioned in the preceding article owned by two or more persons, one of whom is the insolvent debtor, his undivided share or interest therein shall be among the interest or the assets to be taken possession of by the assignee for the payment of the insolvent debtor's obligation. So if there's a co-ownership and one of the co-owners is the insolvent debtor, his undivided share interest in the property shall be possessed by the assignee in insolvency proceedings because it is part of his assets. And the shares of the other co-owners, of course, cannot be taken possession of by the assignee. Now, what is the rule if the property involved is held in trust? Article 2240 provides that property held by the insolvent debtor as a trustee of an express or implied trust shall be excluded from the insolvency proceedings. The trustee is not, strictly speaking, the owner of the trust property, although he has legal title thereto. Hence, the property held in trust by the insolvent debtor should be excluded from the insolvency proceedings. Now, what are the classifications of credits? Medyo gagmay man no? But just go through your codals, no? Kaning Article 2241 pertains to reference to specific movable property of the debtor. Okay? Specific movable property of the debtor. Movable ha? Specific movable property. So nani mga tagsa-tagsa ka categories. Ang 2241 to 2242 pertains to special preferred credits listed in Articles 22 or these pertains Articles 2241 to 2242 pertains to special preferred credits. 2245 pertains to common credits, and then 2244 pertains to ordinary preferred credits. Now, with respect to specific movable property, ang 2241 and 2242 do not give the order of preference or priority of payment. They merely enumerate the credits which enjoy preference with respect to the specific movables or immovables. Okay? Also remember that with respect to the same specific movable or immovable, creditors, with the exception of the state, merely concur. Mo-concur gina sila with one another. Also remember that preference is only given to number one, and the rest should be treated equally. Mauning mga basic principles nga inyong timan-an. Okay? Also note that 2246 pertains to credits which enjoy preference with respect to specific movables, exclude all others to the extent of the value of the personal property to which the preference refers. Ang 2247, if there are two or more credits with respect to the same specific movable property, they shall be satisfied pro rata after the payment of duties, taxes, and fees due the state or any subdivision thereof. So moto akong gi-mention ganiha ang 2242 ang reference ani is with respect to specific immovable property. Okay, immovable. Kaganiha movable man to. So kani with respect to specific immovable property. As you can see the enumeration, no? Taas-taas di siya. So please take the time to really go through each of the enumeration. Now, for the unpaid price of real property sold upon the immovable sold, let's look at the Barreto versus Villanueva case. In this case, appellant spouses Barreto assailed the decision of the Supreme Court in or on January 28, 1961, asking for reconsideration and praying that a new one be entered, declaring that their right as mortgagees remain superior to the unrecorded claim of herein appealee for the balance of the purchase price over rights, title, and interest in the mortgage property. Si Rosario Cruzado sold all her right, title, and interest and that of her children in the house and lot involved in to Pura Villanueva for 19,000 pesos. The purchaser paid 1,500 in advance and executed a promissory note for the balance of 17,500. So the buyer, however, could not or could only pay 5,500. So on account of the note, for which reason the vendor obtained judgment for the unpaid balance. In the meantime, the buyer, Villanueva, was able to secure a clean certificate of title and mortgage the property to appellant Magdalena Barreto, married to Jose Barreto, to secure a loan of 30,000 pesos. The said mortgage having been duly recorded. Now, in this case, si Villanueva defaulted on the mortgage loan in favor of Barreto. So, si Barreto foreclosed the mortgage in her favor, obtained later on a judgment, and upon its becoming final, asked for the execution on July 31, 1958. Now, pag August 14, 1958, si Cruzado filed a motion for recognition of her vendor's lien in the amount of 12,000 pesos plus legal interest, invoking Articles 20, 42, 43, and 49 of the new Civil Code. After hearing, the court below ordered the lien annotated at the back of the certificate of title, with the proviso that in case of sale under the foreclosure decree, the vendor's lien and the mortgage credit of the appellant Barreto should be paid pro rata from the proceeds. Now, silang Barreto insists that the vendor's lien under Articles 2242 and 2243 of the new Civil Code of the Philippines can only become effective in the event of insolvency of the vendee, which has not been proved to exist in the instant case. And the appellee Cruzado is not a true vendor of the foreclosed property. Under the system of the Civil Code of the Philippines, however, only taxes enjoy a similar absolute preference. All the remaining 13 classes of preferred creditors under 2242 enjoy no priority among themselves and must be paid pro rata, that is, in proportion to the amount of the respective credits. Thus, Article 2249 provides that if there are two or more creditors with respect to the same specific real property or real rights, they shall be satisfied pro rata after the payment of the taxes and assessments upon the immovable property or real rights. But in order to make this prorating fully effective, the preferred creditors enumerated in numbers 2 to 14 of Article 2242, or such of there as have credits outstanding, must necessarily be convened and the import of their claims ascertained. So it is thus apparent that the full application of Articles 22, 49, and 42 demands that there must first be some proceedings where the claims of all the preferred creditors be highly bindingly or may be bindingly adjudicated, such as insolvency, the settlement of decedent estate under Rule 87 of the Rules of Court or other liquidation proceedings, or similar import. So this explains the rule of Article 2243 of the new Civil Code that the claims or credits enumerated in the two preceding articles shall be considered as mortgages or pledges of real or personal property or liens within the purview of legal provisions governing insolvency. So as the rule is further clarified in the report of the Code of Commission ng Supreme Court, the question as to whether the Civil Code and the insolvency law can be harmonized is settled in Article 2243. So the preference named in Articles 2261, 2262, now 2241, and 2242 are to be enforced in accordance with the insolvency law. Thus, niingon ang Supreme Court, it becomes evident that one preferred creditor's third-party claim to the proceeds of a foreclosure sale, as in the case now before us, is not the proceeding contemplated by law for the enforcement of preference under Article 2242, unless the claimant were enforcing a credit for taxes that enjoy absolute priority. If none of the claims is for taxes, a dispute between two creditors will not enable the court to ascertain the pro rata dividend corresponding to each, because ng Supreme Court, the rights of the other creditors likewise enjoying preference under Article 2242 cannot be ascertained. Wherefore, the order of the CFI of Manila now appealed from, decreeing that the proceeds of the foreclosure sale may be apportioned only between appellant and appellee is incorrect and must be reversed. In the absence of insolvency proceedings, the Supreme Court or its equivalent, the conflict between the parties now before us must be decided pursuant to the well-established principle concerning registered lands, that a purchaser in good faith and for value takes registered property free from liens and encumbrances other than statutory liens and those recorded in the certificate of title. There being no insolvency or liquidation, the claim of the appellee as unpaid vendor did not acquire the character and rank of a statutory lien co-equal to the mortgagee's recorded encumbrance and must remain subordinate to the latter. We are understandably loath ngayon na Supreme Court to adopt a rule that would undermine the faith and credit to be accorded to registered torrents titles and the nullify the beneficent objectives sought to be obtained by the Land Registration Act. Ngayon, upon the other hand, it does not appear excessively burdensome to require the privileged creditors to cause their claims to be recorded in the books of the Registry of Deeds should they desire to protect their rights even outside of insolvency or liquidation proceedings. So in this case, the Supreme Court, therefore, when after defaulting in their payments due under the resale contract with the RFC, the appellants sold to Villanueva the rights, title, interest, and dominion to the property, and they merely assigned whatever rights or claims they might still have thereto. The ownership of the property rested with the RFC. The sale from Cruzado to Villanueva, therefore, was not so much a sale of the land and its improvements as it was a quitclaim deed in favor of Villanueva. In law, the operative sale was that from RFC to the latter, and it was the RFC that should be regarded as the true vendor of the property. And at most, the Cruzados transferred to Villanueva an option to acquire the property, but not the property itself. And their credit, therefore, cannot legally constitute a vendor's lien on the corpus of that property that should stand on an equal footing with the mortgage credit held by the appellant Barreto. Okay? Also note of these articles, no, 2248 and 2249. Credit transactions really are exhausting, guys, no? So, nature of claims or credits in articles 21 or 2241 and 2242. Please read na lang these articles, okay? And then, order of priority only with respect to insolvency-free property, okay? Specially preferred credits, these are credits which are specially preferred because they constitute liens and take precedence over ordinary preferred credits so far as concerns the property to which the liens are attached. Ordinary preferred credits only in respect of the insolvency-free property is an order of priority established in Article 2244. So non-preferred, 2245. Please read these guys in the order of preference of credits. This has been extensively discussed in your book. So please check out your books. You also know that the pro rata rule does not apply to credits annotated in the RD in virtue of judicial order by attachments and executions, which are preferred to later credits. In satisfying several credits annotated by attachments, the rule is still preference according to the priority of credits in the order of time. Okay? That's in the case of Manabat versus Laguna Federation of Facumas. Kindly read na lang this case. And here.
All right, next meeting we will discuss more about pledge, chattel mortgage, real mortgage, antichresis, as well as concurrence and preference of credits. Thank you very much. I'm Ping.